I'm standing in front of Folsom State Prison, and I want to tell you 4 numbers that are very important to this prison. The number 2, the number 1880, 2500, and 93. The number 2, Folsom Prison, is the second oldest prison in the state of California. 1880 is the year that Folsom Prison was first opened for business. 2500 is the number of inmates that are housed inside of Folsom Prison. And 93 is the number of executions that have taken place at Folsom Prison. And every one of those executions was by hanging. And each of those inmates that was executed is buried on the grounds of Folsom State Prison. Now, executions in the state of California are no longer done by hanging, and they're no longer done at Folsom Prison. As a matter of fact, there hasn't been an execution in some time in California. So that's Folsom Prison. Next door is the new Folsom Prison. We can talk about that one later. But first, we're going to start out talking about the language of criminal statutes, and that is how laws are written in California. For example, the Penal Code and the Vehicle Code, and how we read them and interpret them. So take a look at our friend here. This is what you might imagine when somebody's breaking into a house. And there is a criminal statute that prohibits people from committing this act. And that criminal statute or law is broken down into elements. In order for this guy to be in violation of, let's say, burglary, he has to commit each of the elements of the crime. So I'm going to show you a little bit of Section 459 of the California Penal Code, and this is also called a criminal statute, which really means law. And 459 of the Penal Code says that every person who enters any house, room, apartment, shop, warehouse, store, and it goes on and lists many different kinds of buildings, but the catch-all is that it says, or other building, with the intent to commit a theft or any felony is guilty of burglary. So if this guy that you see in the picture is arrested, the DA is going to have to prove to a jury that this guy, number 1, entered, that's an element, that when he entered he had the intent to commit a theft, that means steal something in the house, or maybe not. Maybe he entered with the intent to commit a felony. That could be murder or rape. Believe it or not, he's also guilty of burglary because he satisfied all of the elements of that crime. So this is how a statute looks. So keep that in mind as we look at some of the criminal statutes in California. You have to take the language literally, and you have to ensure that the person committed the crime by satisfying all the elements that are listed in the section. In California, if a statute is not written down somewhere, it's not illegal. The only things that are considered crimes in California are acts or omissions, that is, you didn't do something you were supposed to do, pay child support, or an act like breaking into a house, that those have to be listed, and the law has to show you what the punishment is. So in this case, if you look just a little further down in the Penal Code, right after 459, which is burglary, you'll get to 461, and that explains or describes the punishment for burglary in California, which in this case, the statute says burglary is punishable as follows. Paragraph A says burglary in the first degree. We can break that down more later, but first degree burglary is when you enter an inhabited dwelling, which means a place where someone lives. That's considered a more serious crime because there's a higher potential that there's going to be violence or someone's going to get hurt when you break into a person's house. The home is also considered more protected and more of a sanctuary in this country, that a person's home is their castle. So when someone breaks in, that's a first degree burglary when it's into an inhabited dwelling, and the punishment for that is, according to paragraph A, that individual would be imprisoned in the state prison for 2, 4, or 6 years. That's without enhancements. We will talk about enhancements later, like having a gun with you being armed in the commission of this crime. But for the moment, first-degree burglary is punishable as listed. And then paragraph B says burglary in the second degree. The punishment for that is imprisonment in a county jail, and that would be not exceeding 1 year. So that's starting to sound like a misdemeanor to me. Or 1 year imprisonment pursuant to subdivision H of 1170. We're going to talk more about that, section 1170. It has to do with a change in the law about housing prisoners that are supposed to be in state prison, but housing them in county jails. It's called realignment, and it occurred a few years ago, I think 2011 or thereabouts. And prison realignment took a lot of the people who were housed in state prison and put them into county jails. So this is just a look at a criminal statute and what they look like and how we read them. Keep in mind that when we're looking at statutes, we always use the most plain meaning. We don't try to read into it. There's nothing fancy about it. There's not a lot of legalese or legal terminology. The idea is that the legislature tries to use the most plain and understandable language. Sometimes common sense will override the language that you see. This is up to the courts to interpret. Or if there's an obvious purpose of the legislature, like, let's say, disturbing somebody's peace or quality of life, and that's subjective, so you have to look at the legislature's intent on that. But just keep in mind that plain meaning is the way we look at statutes. The overall concept of the justice system is that the defendant, that is the person who's charged with a crime, is entitled to every reasonable doubt. If we use words from foreign sources, and sometimes we do, we use a lot of Latin words, and words that have foreign origin or derivation, we need to always use the commonly understood meaning of that word as it is in our culture. So those are just some ground rules for reading laws. Which brings me to vague and indefinite statutes. Laws have to be clear, and that's one of the reasons we use plain English, that they be as plain and as literal as possible. Because when there is ambiguity and it's vague as to what the statute means, that really subtracts from the due process. When a statute or a law has an uncertain or unclear meaning, there's not a precise or exact use of words, those types of laws, if they are enacted, could result in a violation of due process. You have to be clear. And an example would be if you were to use immoral behavior. Immoral behavior is subjective to the reader. So if you're going to use non-specific words like immoral or even loitering, you have to be more specific and define what exactly you mean by immoral. Those definitions have to be written into the statute. Just remember, when you have subjective terminology that could be interpreted different by anybody who reads it, it has to have an explanation of what is meant. And when these statutes are written, we always look to the legislative intent. What did the state legislature, that is the lawmakers, intend to accomplish when they enacted this law? Let's talk about letter of the law versus spirit of the law, and you'll hear this a lot. It means that a letter of the law is exactly what the law says. So if I were a police officer enforcing the law, and I'm looking at the letter of the law, and I see, let's say, a 2-year-old urinates in public. The law says you can't urinate in public. And when the legislature created that law, the spirit, in other words, their intent was they didn't want people, maybe who had been drinking, adults, urinating in public. They did not mean a little kid who isn't potty trained yet. If a police officer sees a toddler who goes potty in public and writes that toddler a citation, that police officer is following the letter of the law. In other words, that officer would say, the law says right here, black and white, you can't do that, and so I'm going to write this kid a ticket. Well, that's the letter of the law. We put an awful lot of effort into training police officers to use judgment and to always look to the spirit of the law. What did the legislature, what were they trying to solve when they created this particular law? Hopefully, most police officers would not write a ticket because that's not what the legislature was trying to solve. Let's say you have a little old lady with a cane and she's walking down the sidewalk in a business district and she steps off the curb because she loses her balance a bit and goes into the roadway. The letter of the law says that a pedestrian shall not leave the sidewalk between intersections in a business district unless the pedestrian does it at a crosswalk when the crosswalk says to cross. That's jaywalking. A super diligent police officer might go over and cite that woman for stepping off the sidewalk in the middle of the block, but that doesn't really fit the meaning of spirit of the law. That was, yes, a literal violation of the letter of the law as written, and technically she did violate it, but really that's not what the legislature intended when they created the law. So that's, in a nutshell, all there is to it when you talk about letter of the law versus spirit of the law. In California, we operate on the premise that California law is bound by the spirit of the law, in that we look to what was the intent of the legislature. That doesn't always make your job easy when you're in law enforcement, because you do have to spend some time trying to think about the reasoning behind a law, but it really helps officers dispense justice in a way that is not completely robotic. Courts not only look at the literal meaning of words, but also the spirit in which the law was written and its legislative intent, as I mentioned. What did the legislature intend to solve by creating this particular law? So even beyond the point of an arrest, when it does go to a prosecution, into a courtroom before a judge, the court will be looking at the spirit of the law heavily when deciding whether or not to hold somebody accountable. If you have language in a law that could be interpreted two different ways, we use the way that is more favorable to the defendant. The law will look at the more favorable path. Sometimes you have conflict between statutes, between laws. So two state laws, if they punish exactly the same act or omission, they are obviously in conflict. You know what I'm talking about when I say omission. I mentioned it earlier. The law says that you are prohibited from doing certain things like slapping somebody in the face, right? But an omission is, the law also says that you are obligated to do certain things and you have certain responsibilities. Let's say to a minor child to provide home and food and shelter. And if you have an omission, the law can apply to you in that regard as well. There are laws that punish omissions. So when you have two laws that are obviously in conflict, then the one that is passed more recently, the newer law, that one will be the controlling law. Let's look at some terms. These come right out of Penal Code Section 7. First, we'll look at the term willful. What that means is that the person who committed an act had a purpose or a willingness to commit this particular act. It does not matter if the person knew that this was going to be against the law. The willfulness applies to just the act. Most laws don't require a person to even know that something was illegal. If they committed the act and they meant to commit the act, whether or not they knew it was illegal is irrelevant. They're still in violation. So willfulness talks about a person's willfulness to commit the act that they did. They don't have to know that act was illegal to be held accountable for it. Next is negligence. Now, negligence is when you have a duty to be careful, let's say driving a car. The consequences of not driving carefully can hurt other people. When you have negligence, that means you have a want or kind of a willful lack of attention to the consequences, which a normal person would understand and know about. You are not paying attention to those consequences like a normal person would. That doesn't mean you just made a mistake and you were trying to drive and you accidentally didn't see something and hit it, or you missed a turn. That's not what we're talking about here. We're talking about your duty to be careful. Now, if you're texting and driving and you miss the turn, that is negligence, because a reasonable person in this society understands texting and driving don't go together. You will be negligent in your operation of the vehicle, and therefore you will have contributed to the crash because of your negligence. Now, this is escalating to malice. Malice is when you do an act and you really are trying to hurt or bother somebody. To vex, which means to annoy or bother someone or injure another person. You have an intent to do something wrongful. You know it's wrongful, you're trying to be harmful. That is malice, and it's a higher level. Some crimes, if you have malice, it can add to your prison sentence if you're convicted. And then the term knowingly, only the knowledge that the facts exist. So if you knowingly walk into a supermarket, now you know that there was a market there, you know you were walking in and it was open for business or whatever. It doesn't require any knowledge of unlawfulness. So let's say you knowingly go into a store that's closed and it just happens to be unlocked. This is just a legal term for state of mind that you knew what you were doing and the facts surrounding what you were doing, not that you knew it was illegal or wrong. This comes up when people are excused from crimes under certain circumstances. Sleepwalking, for instance. They're walking into this closed store, but they're sleepwalking, and they really didn't knowingly go in there. They were unconscious or asleep. That's just one example of an act where the knowingly part would be missing. We'll talk more about that later, but just note that term exists. In criminal law, there are 3 levels or classifications of crimes. It depends on the seriousness of the crime. The way we measure these is by their punishment. The most serious crimes have the most serious punishments, and those are felonies. Penal Code Section 16 describes the different levels of crimes, starting with felony. A felony is the most serious type of crime, and it's punishable by any of the following: death, state prison, or a county jail for a felony term. Remember that statute I mentioned earlier that talked about housing state prison inmates in a county jail? This is what they're talking about. You can do a prison term in county jail under certain circumstances. That's part of the definition of a felony now. An example of a felony would be a burglary, a robbery, assault with a deadly weapon, shooting at somebody, pulling a gun out and robbing a store. Those kinds of things are felonies. The middle one, misdemeanors, shoplifting, petty theft, drunk driving is a misdemeanor. These are moderately serious, and typically they're punished by county jail, no more than a year. Typically it's 6 months, no more than a year in county jail. That's what the statute says, and or a fine. So you might just get fined, you might get put in jail, or both. You could end up with probation. There are a lot of ways to punish it, but these are the definitions. And finally, an infraction. This is the least serious type of a crime. It's punished by a fine, never by jail. You don't have a right to a trial by a jury. You don't have a right to a public defender at the public's expense. You can pay for one yourself. A common example of an infraction, you've all heard of it, is a traffic ticket. You get pulled over for speeding. You get pulled over because an officer thinks you ran a stop sign. You get a citation. You are issued a ticket, which is a signed promise to appear in court later and deal with it. And there's no jail time behind it. If you fail to appear or something like that, that might turn into a separate misdemeanor that could be punishable by time in jail. Here they are again, as I mentioned, felony punishments: death or life in prison, or a term in the state prison. That could be 2 years. It could be life. Or a term in county jail, I should say a felony term, and that's the 1170H, and that has to do with prison realignment. And finally, another punishment, you could get felony probation, which means you get a prison term, but it's suspended. You're put on probation, and if you're a good person and you don't violate your probation, then you don't have to go to jail. If you do end up violating probation, then your suspended sentence is enacted and you get, as they say, rolled up and sent to prison or jail. So here's AB 109 I talked about. It was 2011. It's also called realignment, and the intent was to shift the responsibility for housing a large number of felons from the state to the county jails. And this all came about because of an accusation that the prisons were overcrowded and that there was insufficient health care being provided and too many prisoners per cell and so on. And so a lawsuit was brought. It was a federal civil rights lawsuit for cruel and unusual punishment. It was under the Bill of Rights. Somebody brought a federal lawsuit. The federal government got involved and ordered the state prisons, or the state of California, to do something about it, to reduce the number of inmate population by quite a large amount. I think it was on the order of 30%. They had to reduce the prison population. The plan was, under AB 109, to now make sentencing for certain offenses, lower level offenses, to having the defendant serve their state prison sentence in the county jails. And so the counties had to adjust to this, and they had to house a lot more people than they were, and they had to stop incarcerating a lot of low-level misdemeanors so that they could make room for these prison inmates. When the courts were convicting people, they would convict them under this new statute and send them to county jail instead of state prison. So many of the felony statutes were modified, as you saw, to be punishable in the county jail, not state prison under 1170H. It's still a felony offense, but they do time in county jail. A non-prison felony will state in its statutory text, under the punishment part, that the violation is punishable pursuant to subdivision H of 1170. And if it doesn't contain that language, it's just like the old days, it's state prison. Some defendants, because of their history, because of their background, are ineligible to receive the 1170 type sentence. In other words, they would just have to go to state prison. They don't get the county jail option. Usually that's people with a prior strike, registered sex offenders. There is a list of people with violent pasts that don't get to enjoy the, I guess, the lower level housing situation of a county jail than a state prison. So they would be excluded. But the laws had to be modified to show this option to the judge. Probation is just, like parole, is an extension of your prison cell. And it's an agreement between the court and the defendant to avoid prison or that county jail sentence that we talked about. Probation just means, hey, I agree to let the police search me and my probation officers search me whenever they want, not to use drugs, not to commit any crimes, not to associate with certain people that might be listed in the probation order, and really any other custom orders, terms of probation that might be imposed and agreed upon. So the defendant does have to give up some rights and maybe be subject to search without cause any time. In exchange for that agreement that they will behave, they don't have to go to prison as long as they don't violate the terms of their probation. So felony probation is usually a desired option for somebody who's convicted of a felony. They certainly would prefer that, even with its limitations, to having to go to prison. In that case, a defendant is supervised by a county probation department. Every county has one. And if that defendant violates any of those terms, then the court can just send them back to prison. Misdemeanors, punishable by county jail or a fine. It's a maximum of 6 months unless stated otherwise. So the statute will say 12 months sometimes, but most of the time it's 6 months. But it cannot exceed 1 year in jail, and that's the definition of a misdemeanor. You can get probation for misdemeanors as well, and it's going to be the same type of agreement between the court and the defendant, and that will avoid that jail term. Wobblet, this is a funny little word, and it's got a sister or a brother word called wobbler, and we'll talk about that in a bit. But a wobblet, you won't see a lot of these, but it is a misdemeanor conviction that can be reduced to an infraction. It can be treated like an infraction by the court when they're sentencing, by the DA when the DA is making charges. They can say, you know what, we're just going to reduce this to an infraction. That's a wobblet. The more common one is this one here. It is wobbler. So the wobbler is the same idea, but it's a felony that can be treated like a misdemeanor. You don't have to worry too much about this when you're in law enforcement, because as a police officer, deputy sheriff, CHP officer, whatever sworn officer, when you're enforcing the law and you have a felony / misdemeanor wobbler, if it has both punishments, in other words, you're looking at the burglary, that was a good example. Second-degree burglary, that was not an inhabited dwelling. That one can be punished either way. It can go felony or misdemeanor. That's a wobbler. So to finish my thought, as a police officer, you don't worry about that. You treat and you charge and you arrest and book always as if it's a felony. This wobbler business is for the DA and the court to use when they're prosecuting or sentencing the individual. So police officers always treat wobblers as the higher of the levels. So a wobbler would be treated as a felony. There it is. An arrest for a felony wobbler is treated as a felony arrest. We don't have the option in the field to treat it as a misdemeanor. We know this. A fine, traffic tickets. Health and Safety Code 11357B, that's possession of marijuana, at least for the time being. As long as it's just regular marijuana under an ounce, then not a crime when it's for personal use. And again, no right to a jury trial, no right to a court-appointed attorney. If you want an attorney, you got to pay for it yourself. Otherwise, you just go to court. So, we are going to take a look at how the enforcement of a criminal statute would go from beginning to end, starting with the call to the 911 center all the way to the very end of the process.
Send an ambulance to 1574 First Street.
What's going on there?
My son stabbed my husband.
Your son stabbed your husband?
Yes.
Okay.
Hurry.
Is he, how old is he?
Just come right now.
Okay.
He's 45.
How bad is he injured?
I don't know. I stabbed him deep.
Okay. Has he still got the weapon?
1574 First Street. Come.
Doing this all my life.
Did you hurry?
Okay, we dispatching him now. Hang on, ma'am. Who has the knife right now?
No one.
Okay.
I have it.
You have it?
I pulled it out. Come.
Okay, we got the officer on the way now.
All right.
Like in the B2 unit.
Why are you so mean?
How old's your son?
Oh, hurry up.
Get in the hospital.
Hurry up.
We have the officers en route now, okay?
All right.
Oh, that'll be all right.
Oh, goddamn, Mark.
L8, report of a 245 with a knife, 1574, number 1 Street. RP advising a son. Use a knife on the father. She is in possession of the knife at this time. We dispatching to rescue.
Why are you always so fucking...
Okay, so there you have it. That was an actual 911 call. Sounds to me like the woman was reporting that her husband was stabbed by her son. So let's walk through this in the application of criminal law. The individual is reported to have violated the law. So yeah, I guess that's the case here. Somebody called up and said someone else was stabbed. So we'll take that as a violation of the law. That's now been reported. Law enforcement is alerted. They roll out there to the scene of the house. The exercise here is we're going to pull in the different types of laws that are applying as we go through this. I'll start off with the phone call.
911 emergency.
The 911 center received a phone call from the wife and mother of the suspect, and she said a whole bunch of things, incriminating things. You could hear voices in the background and stuff. So the first question to me would be, are there any privacy rules? Can that be used as evidence? You have a lot of activity and commotion going on. And that comes down to constitutional law, the Bill of Rights and the Fifth Amendment and the Fourth Amendment, the right to privacy and the right against self-incrimination. The answer to that is that deals with the expectation of privacy. Did a person have an expectation of privacy in that environment? They're inside of their home, of course. They have an expectation of privacy for the things that they say. But in this case, she called 911. So when you call 911 and you're talking to a law enforcement agency, a reasonable person would not have an expectation of privacy. This has been through the courts, and all of that evidence is available and now belongs to the police department and can be used in the prosecution. So let's move on. Officer or deputy responds and arrives at the location. So far, so good. I don't think we're dealing with anything other than we have sworn officers and they're responding to a location. But at some point, they're going to enter the house. When they go into the house, do they need a warrant? I would ask you first. And since this is really me talking and you listening, I'll tell you they don't, because you've got a report already that somebody is stabbed, and so certainly there's an issue of medical emergency, and that's called an exigent circumstance. So even if the door was locked and the caller or the person in the house did not want to let the officers in, they could force entry and get into the house, because you may have somebody bleeding to death inside the house. And whatever they see and hear and document, because they legally entered the house, is also admissible in court. We are talking about California laws that deal with the acts that they're investigating. That would be somebody stabbed under California law, probably either attempted murder or 245, which is assault with a deadly weapon, the knife. And so the officers have gone in, and we have California laws that are relevant. They're investigating a crime, and also constitutional law, the Fourth Amendment, which is the right against unreasonable searches and entries into your house. This one's reasonable because of the nature of that call. So Fourth Amendment, and in they go, whether or not they're invited. Officers enter, so we know where we are, and the officer observes and makes contact with the suspect. That would be the son. He's still there on scene. Ultimately, he's going to be arrested based on the observations that the officers make. They're going to see a guy laying on the floor in the kitchen with a hole in his chest. There's going to be a matching knife nearby. It sounds like the mother or wife, the wife and mother, pulled the knife out, as she said. So there's a knife that's going to be evidence. They're going to take that knife based on the statements that were made over the phone, let alone any additional statements that might be made while they're on scene. They're going to arrest the son for administering that knife wound on his father. And they're going to take him into custody and take him down to the police station. They're also going to pick up that knife-like object. I guess by then it was in the back pocket of the suspect. So they're going to take that knife because they have a reasonable cause to believe that's involved in the assault. So they're going to take that. That's a seizure of property, Fourth Amendment issue. But they have the right to do that because it is evidence of a crime. They believe it is. And they are in the house legally. That is, they are in a place where they have every right to be. CSI arrives, so they're going to continue to maintain control of that kitchen. There it is. They're going to maintain control of that and bring in more resources. Once they're in legally and they start to discover and investigate crimes, as long as they got in there legally, they can continue to be in there and bring along more resources. In this case, they're going to bring in the CSI people. They're going to interview victims and so on. So again, we're still following along the same California criminal laws that are being investigated, and the constitutional law, which is Fourth Amendment at this point, which says that the officers can be in that kitchen. They got in there legally, and now that they're in there, they're putting together their investigation. They're also interviewing the wife. They're going to get her statements as a witness, and they're going to interview the son later when he's down at the police station. The defendant, that's the son in this case, he's taken down to the police station. There he is. And they're going to interview him in custody. He's got handcuffs on. He's under arrest. He's in the police station. And now the Fifth Amendment of the Constitution applies. You've heard people say, I plead the Fifth. That means I'm not going to testify against myself. So if they ask him for a statement and they ask him what happened, these are incriminating questions that they're asking while he's in custody. This is a Fifth Amendment issue, and he has the right to remain silent. You've probably heard that term before. He does have the right to remain silent, and he has the right to speak to an attorney. In this case, he invokes, and that means I'm invoking my Fifth Amendment right, and I'm not going to talk to you, and I demand a phone call. He gets a phone call, but there is a point where he is entitled to the phone call, and we haven't crossed that point yet. We might as well let him call his lawyer if he's demanding to speak to a lawyer before we question him anymore. But in terms of having the right to phone calls, that happens immediately after he's booked. Booked means he's taken to jail and he's booked for some charge. Then immediately after that, as soon as practical, he should be allowed to make these 3 phone calls. If 3 hours go by, then it doesn't matter if he's booked or not. We've got to give him a phone and let him make those phone calls. The law says that these calls may be made to an attorney, a bail bondsman, and a relative. That's the intent. But the reality is they can call anybody they want. Now, the officers finish dealing with the defendant and they book him for a crime. Within a couple of days, the district attorney has to file charges. He has to be arraigned, and that's his first hearing, first of many. But the very first hearing that the suspect gets is called the arraignment. The arraignment is where the defendant is allowed to enter a plea. That plea can be guilty or not guilty or nolo contendere or no contest. Then they get a preliminary hearing. That can be down the road a ways. Usually by then they've got an attorney and the DA has prepared their case. The preliminary hearing is when the judge looks at all of the facts surrounding the case. It's almost like a mini hearing. There's no jury involved. And the DA says, okay, here's the suspect, here's what happened, and here is an overview of the evidence that I have that says that this guy did it. The defense attorney can argue at the preliminary hearing that it was an illegal arrest, his rights were violated or something, but it's a very basic hearing where the judge says, you know what, there is sufficient evidence to hold the suspect to answer at trial, meaning we're going to go ahead and charge him, have a court trial, like a jury trial. So the preliminary hearing is basic, but it's a judicial review of the facts and circumstances and evidence that has been accumulated. The judge decides, let's go to trial. Another decision the judge could make is, you know what, I don't think there's sufficient evidence here. I'm going to order that the defendant be released, and the DA has to start over again. So at the preliminary hearing, the defendant is held to answer in our example here, and later he'll go to trial. The trial is the full-blown presentation by the DA of all the evidence and all the testimony and all the witnesses who are cross-examined, and then the defense presents their case and their arguments before a jury of 12 people who are selected by the court and agreed upon by the 2 attorneys. If the individual is found guilty, which requires that all 12 jurors agree that he is guilty beyond a reasonable doubt, then the trial is concluded. He's found guilty, but he comes back later for sentencing, and that's the next hearing. The judge has every intent to sentence him, but he wants to know some background on this individual first. And that's when the probation department prepares a report saying this guy has been in trouble 5 or 6 times, he's been on probation and parole, he's been to prison, or maybe they don't have that information. The defense might say he's a model citizen, we've got letters that say he's such a great guy, he shouldn't be sentenced. The judge considers all of that. The judge also at sentencing must hear from the victim. Victims are now allowed to present a victim impact statement. The judge considers all that and then levies a sentence. And the law gives the judge a range of years in prison that he can give to the defendant, depending on the person's history and the severity of the case at hand. Finally, the last step is incarceration. So when the person is convicted and incarceration is part of the sentence, then the individual is turned over to the California Department of Corrections and Rehabilitation, CDCR, sent to prison. Okay, so the overall enforcement of criminal law starts with the investigation by the city police or county sheriff. In our case, the police responded to a call of a stabbing. And then the whole package, all the evidence that's been collected, is handed over to the prosecution. That would be a district attorney or an attorney general or a U.S. attorney, but it's the DA who presents it all in court. There's a defense side to that equation where the defendant is given the opportunity to have a competent defense. That could be a private attorney or a public defender appointed by the court. And they get their trial, their day in court, and then finally the punishment, and that part is handled by the courts and the judges themselves and the probation department and the California Department of Corrections or state parole. They carry out the terms of the punishment. So that's how each of the pieces of the enforcement of criminal law are broken down by function. Now, once somebody is convicted, they do have the right to appeal. And they might appeal based on any of a number of things. They could challenge the search of the house, that the officers didn't have the right to go in, the fact that the officers took the knife from his pocket. They may challenge that. So they can appeal it. And the appeals are actually heard by a higher level court, California Court of Appeals. They're called an intermediate court. They're above the local superior courts. They hear the appeal when the defendant challenges something, and they make a decision. And there's only one more level in California state system, and that's the California Supreme Court. So in our case, let's say that our suspect appeals to the appellate court. How do the judges decide? Oh, there's a judge we know. Now that's the TV version, but she does follow the same principles when she makes her decisions. Usually they're in civil cases, not criminal cases. Nevertheless, an appeals court judge is going to look first at the U.S. Constitution. In this case, a big issue was the Fourth Amendment. And the Fourth Amendment of the Constitution says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, which means the government taking, police taking the knife, shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. In this case, our defendant is going to challenge that based on the violation of the Fourth Amendment. And of course, in our case, it looks to me like the officers were in compliance with the Fourth Amendment because they had an exigency, somebody injured, and once they were in, they saw the knife, they seized it, and everything seemed to go appropriately. Number 2, stare decisis, case law, precedent. Those are 3 different words for the same thing, which means prior case decisions. A similar fact pattern might have occurred in another case, in another county, at another time. And the decision that came out of the appeal in that case is going to be followed. A defense attorney is going to argue, hey, the same situation applies here. And in that case, the appeals court found that the officers did violate the Fourth Amendment and threw out the knife as evidence. Now, if the knife is no longer part of the case, you don't have a weapon, it's going to be a lot harder to have a conviction. So that might be the premise. Case law is something that judges rely heavily on, but often the attorneys are pointing out the cases for the judge to consider when they're making their decisions on appeal. Stare decisis means adhering to a precedent. Lower courts are bound by the decisions of higher courts. The reason for this system is that the appellate courts, they try to rule with consistency so that cases in Southern California are relatively similar to Northern California. You don't want to be in a state where, depending on where you travel, the laws are applied differently. The reason for the appellate system and the use of case law is to maintain consistency between courts so that the laws are being applied in the same way no matter which of the 58 counties you are in. And of course, state courts are always bound by the United States Supreme Court on constitutional issues. So the U.S. Supreme Court does sometimes hear appeals as they move their way up on constitutional issues, and of course the courts look to the U.S. Supreme Court for what decisions they've made. There are lots of lower-level federal courts. They're called circuits. We happen to live in the Ninth Circuit under the federal system. And our state courts are not bound by those decisions. They certainly would pay attention, but only the U.S. Supreme Court when it comes to constitutional issues. So, precedent. We look at the way things have been decided in the past. Can that ever change? Can things evolve over time? And the answer to that is yes. And it depends on the composition of the court and how judges are ruling on cases and how they're paying attention to each other. Certainly, facts can be different from case to case, but precedent changes over time. More and more decisions in a particular issue that are decided one way can change it. But also technology and society change over time. As an example, in 1973, in the United States versus Robinson, it was ruled that police officers who make a lawful arrest can search the entire person, every pocket, everything they have in their possession. They can search everything. Back in 1973, the court in United States versus Robinson didn't anticipate that people would be walking around with smartphones that contain files with every personal and private document accessible through a Dropbox app, every phone number and contact and all the history and GPS tracking that a smartphone might have. Those things weren't anticipated. So along comes 2014 and precedent changed in terms of searching cell phones. Up until 2000, police officers were searching the cell phones of a person that they arrest because of U.S. versus Robinson. But in 2014, that changed with Riley versus California, and no longer did the police have the right to search the cell phone of a lawfully arrested person. They would have to go get a search warrant, present it to a judge that they have probable cause to believe that there's evidence, specific evidence that they would have to name in the phone. And they would probably have to specify what part of the phone they're going to search and what they're looking for. We're going to stop here. This is part 1. We're going to resume next week talking about propositions in California and how they affect the justice system.